Case number 20 CR 250. State of Ohio, which is Andrew, present for the state, Assistant Prosecutor King, present for the defendant, his attorney Dan Whip. You are Andrew. I'm sorry, Captain. I was just looking at a file for a Captain Hack. And you are Andrew.
Sir.
All right.
Yes, sir.
Okay. All right, Mr. Rackley is charged with grand theft of motor vehicle for felony. The court had a pretrial yesterday and continued today on the pretrial trial is set for April 12th. Now, Mr. Rackley has been presented with a plea guilty form, which indicates that you're going to withdraw your not guilty plea, plead guilty to the charge. And it is a 3-page document. On page 3, there are signature lines. And at the very top of this page, there's a line that says, I enter this plea voluntarily. And the signature below, which looks like Andrew Rackley, is that your signature on the hand?
Yes, sir.
And did you just sign this here this morning?
Yes, sir.
Okay. And before you signed it, did you go over with your attorney?
Yes, sir.
She explained it to you. And you understand that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing.
Yes, sir.
Okay. Have you had enough time to fully consider this matter before making this decision?
Yes, sir.
And do you feel that you've been pressured in any way to make this decision? You need to keep your voice up, because we're having a little bit of trouble.
Your Honor, we don't have the mics.
All, yeah. Please don't go get the remote mics, we've got them out there and be charged. And are you entering into this plea agreement voluntarily?
Yes, sir.
Okay. I tell you what, take your mask off and speak up louder. Okay. Are you entering into this agreement voluntarily?
Yes, sir.
Okay, thank you. Now, the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to the charge of grand theft of motor vehicle under 2913.02A1A43 felony, and it states that you understand that the possible maximum penalty for that could be 18 months in prison, minimum would be 6. There's also a fine available of up to $5,000. You understand that?
Yes, sir.
Right now, are you facing any felony charges anywhere else?
No.
And are you currently on probation, parole, community control, or post-release control for felony in your jurisdiction?
Probation.
From where?
Okay.
Okay, but other than this case,
Choke off.
is that up for felony or misdemeanor?
It's a misdemeanor.
Misdemeanor. Okay. Right. Now, under the law, if you're convicted of this offense, and the court sentences you to prison, once you complete the prison term ordered by the court, you don't parole for a week, may, at their option, put you under post-release control for a period of 3 years, which means you'd be supervised by a parole officer under the term set by the parole authority, because the judge has nothing to do with that. Now, if during the period of time that you're being supervised, they decide that you have failed to comply, then they have the authority to return you to prison, even though you served the prison term already imposed by the judge, for an additional period of up to, in this case, half of the prison term that was imposed for one or more violations. But if you commit a new felony while you're under post-release control and supervision, then in addition to whatever sentence the judge could impose in the new case, that judge could also sentence you to an additional period, in this case of 1 year, or whatever time would be left on that 3 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to sentence in the new case. Do you understand that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. That means that instead of going to prison, you'll be put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. Now, if during that period of time the probation department feels that you're not in compliance, then they can file a written charge alleging that, and give you a copy, and then you would have a hearing and be entitled to be represented by an attorney. Now, if the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your committing control and then send you to prison for 18 months to fine you $5,000. You understand that?
Yes, sir.
Right now, the charge alleges that on or about January 5th of 2021, I'm sorry, that's the date of the spot, the indictment, on or about October 24, 2020, in Highland County, Ohio, you did purchase a private corner pharmacy, owner of property, you only had exert control over said property to a 2012 Ford van, being a motor vehicle as defined under ORC section 4501.01, without consent, corner pharmacy, the owner of personal authorized to give consent, violation section 2913.02A1. So that's the grand theft of motor vehicle charge, the fourth degree felony that I just explained to you. Now, do you understand what it is you're charged with, what the state said you did, when, where, how they let you did it?
Yes, sir.
Do you understand the possible penalties for that offense?
Yes, sir.
All right, now, have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible defense you might try to raise in trial, possible outcomes of a trial with your attorney?
Yes, sir.
Sorry?
Yes, sir.
Okay. And are you satisfied with her advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Right now, has anyone threatened you to get you to plead guilty here today?
No, sir.
Now, on the second page of the agreement, it's printed in bold this language, and it's underlined. Defendant shall enter and plead guilty to the indictment. State defense jointly recommend community control and substance abuse treatment. Defendant agrees to make restitution to Corner Pharmacy LLC amount of $510. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to enter into this agreement?
No, sir.
Under the law, Mr. Brackley, the recommendation of sentence is not binding on the judge. So even though the state, the prosecutor, and you are saying that you should be put under community control or probation, once I've heard all the information, I'm not required to follow that recommendation. If I decide that's not the proper sentence under the evidence of the law, I could go ahead and send you to prison for between 6 and 18 months and fine you $5,000. You understand that?
Yes, sir.
Now, do you hold any license or certificate from the state or any kind of trade or occupation? Is that a profession?
Yes, sir.
You have certain constitutional rights and understand Mr. Brackley before I can accept the plea or be guilty. First, you have a right to have an attorney. Ms. Hacker was appointed to represent you, not simply to work the case out, but to provide whatever defense might be available to you under the law that you wish to provide. So if you decide that you do not want to plead guilty, you will still be represented by Ms. Hacker to defend you, including having a trial if that's what you want. You understand?
Yes, sir.
In the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county who are summoned for a jury. Once 12 are selected, evidence will be presented, the jury will be instructed on the law. And then that jury will decide by unanimous verdict, when all 12 have to agree on whether or not the state proves your guilt of the charge. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up in writing, the right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, it would be the judge who hear the evidence, the judge will apply the law, the judge will decide whether or not the state proved your guilt by proving beyond a reasonable doubt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you and to have them cross-examined in open court. What that means is the witnesses against you would have to come into this courtroom and testify in front of you and your attorney and anyone else is present. If the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney. You also have the right to use the power of the court to compel or force witnesses to come to court and testify for you, just like you said. What that means is that the witnesses that you feel to help your case, you're not certain they're going to come in voluntarily, request the court to issue a court order that's called a subpoena, and then those people will be forced to come to court and testify if you want them to, even though they don't want to be involved, which is the same way the state's witnesses are forced to come into court to testify. You understand that?
Yes, sir.
Right, under the Constitution, directly you have the privilege of self-incrimination, which means you cannot be forced to testify or give evidence against yourself in this matter at any time before the trial. So no one can ever make you testify. The prosecutor can, the judge can, you decide. You decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time. In fact, no one will be allowed to talk about it except one situation, and that is if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider that for any purpose. You understand that?
Yes, sir.
Under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof is on you to prove you're not guilty simply because you've been charged with this crime. In fact, under the law, you're not required to present any evidence to defend yourself in a trial. You can, but you're not required to. Whether you present any evidence in your own defense or not, the burden of proof will remain on the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that is known under the law. Do you understand that?
Yes, sir.
All right, now, under the, you originally entered a not guilty plea. Not guilty plea denying the allegations in the indictment denied you committed any crime. That exercise revoked all the rights that I've just described. You change your plea from not guilty to guilty, that's the complete opposite of not guilty plea. Guilty plea admits the allegations in the indictment admits that they're a crime, and that you committed that crime. And that plea waives gives up all of the rights that I've just described for you here. And except your right to have an attorney, which you always have no matter what your plea is. But with that exception here, plea of guilty waive means give up your right to have a jury or a court trial. With waive, give up your right to confront witnesses against you and cross-examine for your attorney. With waive, give up your right to have a subpoena issued to force witnesses to come to court to testify for you, just like the state. Waive, give up your privilege of self-incrimination because if you say you're guilty, the state's not required to prove that you're guilty. It also subjects you to being sentenced immediately by the court. It also waives up your right to require the state to prove your guilt or prove beyond reasonable doubt, because if you plead guilty, they don't have to. It also gives up your right to file an appeal on any alleged violations of your rights you think may have occurred up to this point. And then finally, well, if I do sentence you to maximum sentence or a search circumstance to file an appeal, which you have to be filed in 30 days of sentencing to be filed. And then finally, it waives the subjection to being sentenced immediately by the court, if I think that's the right thing to do. Now, do you understand all of that?
Yes, sir.
Is directly are you a U.S. citizen?
Yes.
Okay. Now, do you have any questions about the charge or the possible penalty?
Yes, sir.
Do you understand them?
Yes, sir.
Any questions about the plea agreement? Understand it? Have any questions about the constitutional aspect of the claim? Understand those? Have any questions about the plea of guilty, what it means, what will happen if you enter in here today? Understand it? Is there anything you would like to speak with Ms. Hacker about before we go any further? And is it your decision to plead guilty to the charge according to the terms of this agreement that I've just gone over with you?
Yes, sir.
Okay. And as to the charge which alleges that on or about October 24, 2029 in Canton, Ohio, you did with purpose to deprive former pharmacy, the owner of property, one that obtained or exerted control over said property to a 2012 Ford van, property being motor vehicle as defined in ORC section 4501.01 of the Idaho Code, without consent of the owner, former pharmacy, or a person authorized to give consent in violation of section 2913.0281, charge of grand theft of motor vehicle, report for felony, and possible prison term between 6 and 18 months and fine of $5,000. How do you plead? I'm sorry.
I didn't hear you.
You need to speak up.
I didn't hear you.
How do you plead? Pardon me?
Guilty.
All right. You be seated. All right, the court finds that on this date of the court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the state pursuant to criminal 11. Please accept that the order filed, defendant is found guilty of the charge is set forth in the indictment, grant theft of motor vehicle, felony. The court will order a pre-sentence investigation to be conducted, which shall include a assessment for substance abuse disorder and or mental health. And we will set the sentencing hearing for April 22nd. That will be at 1 p.m.
No, we had this discussion yesterday. I'm available at 9. But
Oh, okay. Well, we moved those, I believe, to 10.
Okay, that's fine.
Because we had a couple of civil pre-trials. So,
The morning's good with
all right,
afternoon.
10 a.m. then. Okay. Now, you won't need to be here on your trial date, but you're going to get an assignment notice here from the bailiff to remind you of your trial of your date. So as soon as you get done here, you go down to the probation department and tell them that you've been to court, pled guilty, that you need to have a pre-sentence evaluation.
Right, he's currently at the Massey house.
Right.
Okay, so that, I just want to make sure that.
I did that. That's all I found. But so we'll take you down there and you talk to them, and then they'll take a point to do the pre-sentence. And you continue to apply with the retrieval program there next. All right?
Your Honor,
Yes.
will this be by Zoom or in person?
Those will be in person.
In person, okay.
Yeah, all of the April sentences are going to be in person.
Okay.
All right, thank you.
Thank you, Your Honor.
Please rise.